Hi everyone, my name is Chris Carney. I teach mental health law spring quarters at University of Washington School of Law. Today I'm going to be talking about decarceration and public health and our obligation to consider the human rights of people in prisons during a global health crisis. On March 15th of this year, the World Health Organization released a set of policy recommendations for the prevention of COVID outbreaks in jails and prisons. It's important to recognize at the outset that simply by virtue of being incarcerated, people in prison are at higher risk. People in prisons live in close quarters with many other people, usually sharing sleeping space within a few feet of others and sharing the same sinks, toilets, and showers. They cannot socially distance. And often they do not have access to adequate soap and other hygiene supplies. To make matters worse, incarcerated people are more likely than the general population to have underlying health conditions, compromised immunity, and poor nutrition, all of which makes them more vulnerable to COVID. Because it is difficult or even impossible to achieve social distancing and disinfection in jails and prisons, the WHO advises limiting the use of incarceration as much as possible during the COVID crisis. The importance of preventing COVID outbreaks in prisons, however, goes beyond concerns for the safety of people in prison alone. As medical facilities in prisons are overwhelmed, infected people must be transported to nearby hospitals, risking exposure for others. Even worse, because most prisons in the United States are in rural areas, resources for medical treatment are limited and likely cannot handle a mass outbreak. In Washington, the Department of Corrections releases approximately 25 people per day. Asymptomatic but infected people wouldn't know they need to be isolated from their loved ones all over the state if they aren't tested before release. This slide shows the top 5 hotspots for COVID infection in the United States as of April 24th. As measured by percentage of the county population testing positive for COVID. Take a look at this list. Rockland County, New York is a 45-minute commute from Manhattan, so it's obvious why it would be on this list. On the surface, though, the other 4, they don't make any sense. They're all rural, sparsely populated counties. What is it that each of these places has in common? The answer is prisons. In 4 out of 5 of the most significant hotspots in the country, nearly all of the growth in confirmed cases is due to an outbreak raging through prison populations. In each of these hotspots, the key to understanding the outbreak was widespread testing of inmates who were not yet symptomatic. Keep an eye on this list in the New York Times. Google the top counties. I'll be surprised if this trend doesn't continue, with prisons accounting for the hottest outbreaks. This is the CUMMINS unit of the Arkansas Department of Corrections in Lincoln County, Arkansas. On April 12th, the Arkansas Department of Corrections announced the first positive COVID test at CUMMINS unit. 1 week later, a total of 670 inmates and 10 staff members at CUMMINS had tested positive for the virus. Those numbers are undoubtedly higher today. Arkansas is now considering the release of approximately 1,200 inmates. This is the BLEDSOE County Correctional Complex in BLEDSOE County, Tennessee. On April 20th, the Tennessee Department of Corrections confirmed 162 positive cases at the BLEDSOE unit. By April 24th, 4 days later, the agency reported at least 576 cases, with 73 tests still pending from that location. As of April 25th, Tennessee has no plans to release inmates early due to COVID. This is the MARION Correctional Institution in Marion County, Ohio. The first COVID case at Marion was confirmed on April 3rd. By April 23rd, there were 2,011 confirmed cases among inmates and at least 154 cases among staff. 81% of the inmates tested positive. This is the PICKAWAY Correctional Institution in Pickaway County, Ohio. On April 4th, the first inmate tested positive for COVID-19. By April 22nd, 1,536 inmates were diagnosed with COVID. That's 77% of the population of the facility. So far, 8 inmates have died of COVID-related causes from this one institution. By April 6th, the governor of Ohio ordered the release of up to 205 inmates serving sentences for nonviolent offenses out of a total statewide prison population of approximately 49,000. Clearly, it was not enough. Statewide in Ohio, as of April 24th, at least 17 inmates have died from COVID-related causes, and at least 93 were hospitalized. Both of those numbers are certain to increase. This is the Monroe Correctional Complex in Monroe, Washington. MCC has a capacity of over 2,400 inmates. On April 5th, 6 people living at MCC tested positive for COVID. This is a typical cell at MCC. As you can see, social distancing is impossible in this environment. On April 8th, a large group of people occupied the MCC yard and did some property damage, protesting that they were not being protected from COVID. Before even the first positive case at MCC, Columbia Legal Services had filed a petition for a writ of mandamus in the Washington Supreme Court, seeking to compel Governor Inslee and DOC Secretary Sinclair to take steps to protect Washington prison inmates from COVID. CLS filed the petition directly in the Supreme Court because under Article 4, Section 4 of the Washington Constitution, the Supreme Court has original jurisdiction over any mandamus action involving a state officer. Washington law allows a writ of mandamus to compel the performance of an act that is legally or constitutionally mandatory. A state officer, in other words, cannot simply ignore a mandatory duty. However, a writ of mandamus does not permit the court to control how a state official performs a mandatory duty, merely that the official must perform the act. Officials are then charged with using their discretion to determine how to do it. CLS argued that protecting the inmates' health was a mandatory duty and alleged that Inslee and Sinclair were essentially ignoring that duty by failing to have a plan to discharge vulnerable inmates from prisons. Specifically, CLS asked that the state be ordered to release all inmates over the age of 50, all inmates with pre-existing health conditions, and those within 18 months of sentence expiration. This would have meant at least 5,000 inmates. Following the first positive tests at MCC, CLS requested that the court take emergency action in advance of the April 23rd argument date for the petition. On April 10th, the court agreed with CLS that protecting the inmates from COVID was a mandatory duty and ordered the state to take all necessary steps to protect people in prisons and also to file a report explaining their plan. In its April 13th and 17th reports, DOC emphasized its plans for prevention and management of COVID, according to what it said were CDC guidelines, as well as the relatively low percentage of positives among the nearly 300 inmates it had tested to that point. The reports also indicated that the state was in the process of accelerating the release of approximately 1,000 nonviolent offenders using governor's commutations and DOC emergency release orders and furloughs. On April 10th, the State of Washington Office of the Corrections Ombuds inspected MCC in the aftermath of the April 8th protest and issued a report on April 17th. The ombuds reported that MCC is completely unable to impose social distancing and that facility staff and incarcerated people alike asked that inmates be released to create space. The ombuds found that people with COVID symptoms were being held in strict isolation and allowed showers only once per week. Those individuals also had no access to communicating with their families or their lawyers, and no personal property and no recreation. These pictures were taken during the Ombuds inspection and highlight the absence of appropriate social distancing at MCC. On April 23rd, following oral argument, the court denied the petition for the writ of mandamus by a 5-4 vote. The court held that the petitioners did not show that the state was completely failing to perform a mandatory duty. While there is an opinion to come later, the order was terse. However, during the argument, the justices who voted to deny the petition had expressed skepticism that the court had legal authority to second-guess the state's exercise of discretion to plan for COVID management, as long as it saw evidence that there was a plan. The 4 dissenters would have continued to monitor the state's implementation of the plan to ensure that all necessary steps were being taken to protect incarcerated people from COVID before deciding the merits. An interesting note is that Judge Lisa Warswick of the Division II Court of Appeals participated in the case as a pro tem justice. She voted against the petition. Justice Helen Whitener was sworn in the day after the order denying the petition. As of April 24th, Washington DOC has conducted approximately 300 inmate COVID tests statewide out of a prison population of approximately 18,000 people. DOC has not done the widespread testing of asymptomatic inmates that was necessary to reveal the scope of the outbreaks in Arkansas, Ohio, and Tennessee. The Washington Department of Corrections continues to test only people with COVID symptoms or known exposure to COVID. DOC classifies nearly 6,500 of the people in its prison as low risk to reoffend. Yet, as of April 24th, DOC has released only 410 inmates. According to DOC, as of April 21st, there are confirmed cases among employees at Airway Heights, the Coyote Ridge Correction Center, the Washington Correction Center, and a work release facility in Kitsap County. Not including staff, this is over 6,500 people who are resident in those facilities. Unfortunately, Monroe is likely only the beginning of the COVID outbreaks in Washington's prisons.